You mentioned power of attorney. You know, the average person may not know what that is. Would you please explain what a power of attorney actually is?
Well, a durable power of attorney is the financial power or the banking power. And it basically allows whoever you designate to step into your shoes financially and to make all your financial decisions, from banking issues to stock portfolios to real estate to your own business if you have a business. It allows people, it allows your power can there's a gifting provision in there, so if they need to get you Medicaid ready or something like that, or get you ready for a government program, it gives that person the authority to do that, because there's certain, you can only have certain amounts of income and things like that in order to qualify for government programs. So this document is a very, very powerful document, and actually the laws changed as far as the durable power as of October of 2011, and what it took 6 years to develop this new law. The new law was a collaboration between the banking community and lawyers, the Florida Bar. And what it does is it makes the durable power much more tailored to the individual. My durable power was created based on this new law, and what it does is there's certain areas that have to be initialed by my clients, and it shows that that client wants that specific power to be given to their designated.
So what happens when somebody dies to a power of attorney to the?
When somebody dies, that durable power and that healthcare service ends. You no longer have a durable power. You no longer have authority. If you have the power, you no longer have the authority to go into the banks or do anything financially for that deceased person. The power is non-existent. If you do something, you can get in trouble. You do not want to do anything because you don't have that authority. Don't go into the banks. Don't take money out. Unless it's a joint account or something with you, you don't have the authority to do anything for that person anymore.
So if that person has ongoing bills at that point in time, lease or maintenance for a condo, for example, they can't pay that. It has to go on hold.
That's right. Technically, a probate would be started, and the estate would be handled through the courts. It depends on how you've set things up as far as how the properties are titled and things like that, and even the bank account. I mean, if you are a joint signer on that account, you can continue to pay the bills, but it's your money that's paying the bills.
Mm-hmm.
You need to consult an attorney when that time comes, because you need to see what your obligations are and what your rights are. You're talking about, you've got secured creditors and you've got unsecured creditors. Unsecured creditors are usually credit cards and things like that. Secured creditors might be a credit line on the house and such matters. Even if you're homesteaded, if you've got a mortgage or a credit line on that house, those bills have to be paid, or that house, those creditors are not left out. They're attached to the house. So you've got to be careful with that. And the best thing you can do is just go consult an attorney. A lot of us, well, at least I will consult for the first time for free and talk to them about what they need to do and what their steps are. And then they can choose, either choose me as an attorney to help them through the process, or they can go elsewhere. But I always try to make it so that they understand the process. I know not everybody does that, but I just feel, having done it myself and gone through this, especially the last few years, it's important for people to understand what's going on. And they're already so emotional. They really need somebody out there that understands what they're going through, been there, done that, so as to say, and can hold their hand through the process, because it's a fragile time.